Welcome everyone. I'm Lily from PG and Research Department of Commerce, and in this e-content we are going to see about the rights of the unpaid seller. So before going into the topic in detail, it is important to know about what is and who is the unpaid seller. A seller of goods is deemed to be an unpaid seller in the following cases. When the whole of the prices has not been paid or tendered, or where the bills of exchange or other negotiable instruments has been dishonored, okay, and this will be under section 45 subsection 1, and the condition on which it was received has not been fulfilled by the reason of the dishonor of the instrument or otherwise. And if this is going to happen, the person will be termed as the unpaid seller, okay, even partly if the buyer is not going to pay part amount of the goods which he has purchased, then even in that case the seller becomes unpaid. So he must be unpaid and the price must be due, and he must have an immediate right of action for the price. And this is about the meaning of the unpaid seller. Next is the rights of the unpaid seller. As an unpaid seller, the seller has some rights, that is through which he can claim the buyer for his price to be paid, and that is termed as the rights of the unpaid seller. Okay, as a seller he has got certain rights to take action against the buyer. This is the flow chart of the rights of the unpaid seller. Here we have got two dimensions. The as a seller he can take action against the goods and against the buyer, and when he can take the action against the goods, it means when the goods is not in the hands of the buyer, once it is in transit or once it is in the hands of the seller. In these two cases he can take action against the goods, and against the buyer when he can take is that when the goods are passed into the hands of the buyer, then he can take only actions against the buyer. And this is the two major subdivisions under the rights of the unpaid seller. Coming to the against the goods, we have two against subdivisions. Here we have where the ownership is not passed and where the ownership is passed, and we have various subdivisions. Let's see in detail. When the property in the goods has not passed to the buyer, and an unpaid seller has the following rights against the goods. First right is the right to lien. A right to lien is to retain the possession of the goods until the payment of the price is made. It is available to the unpaid seller of the goods where he has got the possession, that is the goods has been sold without any stipulation as to credit. He should not have been sold the goods in the credit basis, and the goods have been sold on credit, but the term has been expired. The credit period should be expired, that should be done, and the buyer would have become insolvent. In these cases he can practice right to lien. And coming to the rules regarding this lien, the lien depends on the actual possession and not on the title. It is not affected even if the seller has parted with the document capable of transferring the sale and stuff. The lien can be exercised by the unpaid seller only for the price and not for any other charges such as warehouse or dock charges and all. Where however as part of the goods is delivered under such circumstances as to show an agreement to waive the lien, the seller cannot retain the remainder. So this is about the right to lien. Next is stoppage of transit. The right of stoppage in transit, this happens when the goods is in the transmitting process, where the possession is not maintained by the seller, but it is in the transport process. No, in that case he can go for this. He has a further right of resuming the possession. See, in right to lane he can retain, but here he is resuming the possession of the goods as long as they are in the course of transit. He can go for, okay, when the buyer becomes insolvent he can go for resuming the goods, and when the goods are in the transit. In these two cases he can practice the stoppage of transit. No, and coming to right to resale, this is done in cases where in most of the cases of perishable goods, in that cases only they will be going for right to resale. That is where the goods are of perishable nature, where he gives notice to the buyer as his intention to resell the goods, and the buyer does not within a reasonable time he is not going to pay, or he is not going to respond for the tender of the price. In those cases he can go for resale. There is of course loss on part of the seller, but still he can go for this right to resale to protect himself from the loss that he has gone through, or he is going to go through. Okay. And when the property is not passed, here the seller can withhold the delivery, okay, where the property is goods has not been passed to the buyer, and unpaid seller has, in addition to his other remedies, he has another remedy too, a right of withholding his delivery, similar to, and it is of that sort of right to lane only, and stoppage in transit where the property has not passed to the buyer is of much similar. And next again he can go for stoppage of transit, even if the goods are not passed. So again he can stop the transport of the goods when the buyer becomes insolvent, and when goods are on transit he can go for stopping, or he can hold the delivery until then the buyer pay for his goods. These are the rights which an unpaid seller may enforce against the buyer personally when the goods are being passed to the buyer. In those cases he can go for this. And in these cases we have 4 circumstances. That is, he can go for sue for price, he can sue for interest, sue for damages, and repudiate the contract. And let's see all those 4 in detail. First is sue for price, where the property has passed, where under a contract of sale and the property in the goods has passed to the buyer, and the buyer wrongfully neglects or refuses to pay the price, then the seller can sue for the price, and he can get back the amount. Where the property has not passed, where under the contract of sale the price is payable on certain day respective of the delivery, and even in this case the buyer is going to neglect, then he can sue for the price. So this is the case. Next is sue for interest. Sue for interest is something where a specific agreement between the seller and the buyer as to interest on price of the goods will be included in the agreement. If they are not going to make the payment in the specified period, then for the time taken by the buyer will be compensated by paying off the interest. This is how it works. Next is suit for damages, where the buyer wrongfully neglects or refuses to pay the amount. In those cases the seller can go for claiming for the damages he has gone through in the manufacture of the goods and stuffs. So that is suit for damages. And repudiation of the contract before due date, where the buyer repudiate, that is, if he is going to cancel the contract before the due date, the seller may either treat the contract as subsisting and wait till the date of the delivery, or he may have the another option, that is, he may treat the contract as rescinded and sue for the damages for the breach. And this rule will be known as how it means the rule of anticipatory breach of contract. That is, he is anticipating that this contract is being breached by the unpaid seller. So this is about rights of unpaid seller. Thank you.